Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about environmental concerns at Shawnigan Lake. Cases that should have gone to the Supreme Court of Canada, but didn't. Cobble Hill Holdings obtained a permit to operate an old mining site at Shawnigan Lake. They also obtained a permit from the provincial government of British Columbia, allowing them to dump contaminated soil at or near the lake. The result was that the lake itself became contaminated, and many people who were concerned about the safety of their community decided to speak out against this. This ultimately resulted in the minister issuing a number of warnings for what the Cobble Hill Holdings company was doing, and finally, in the minister canceling the permit allowing the Cobble Hill Holdings company to continue dumping the contaminated soil. Cobble Hill Holdings sued the BC government, alleging that they had breached a duty of care they owed to Cobble Hill Holdings in canceling the permit and in issuing some of the warnings. It's a very interesting case because they were essentially trying to create a new duty of care that doesn't exist anywhere else in Canadian law. These are the exact types of issues that should go to the Supreme Court of Canada, novel issues that have significant national importance. The question Cobble Hill was asking was whether or not a government agency or a regulatory body, like the Ministry of Environment or the Law Society of British Columbia or the College of Physicians and Surgeons or the Superintendent of Motor Vehicles, owes a duty to the people or companies that they regulate. Do you have an obligation to make sure that when you're granting regulatory permits or revoking regulatory permits, you're doing it in a way that's not negligent? Currently, the law in Canada is that you can't sue for this, but Cobble Hill Holdings was saying that there should be a duty of care found between the regulator and the regulated. And unfortunately, the Supreme Court of Canada didn't think that that was an important enough question to consider. But if you think about how much power regulatory bodies have over the lives of individuals, companies, and everything that we do in our day-to-day life, shouldn't we hold them to some standard? Shouldn't there be some process in place whereby if those decisions or regulatory actions are undertaken in a negligent manner, people have a cause of action? And if not, why is there not a good explanation from our top court to explain how this shouldn't be the thing that we have in Canadian law? It's unfortunate the Supreme Court of Canada didn't see the tentacles of importance that were spread through this case into all areas of Canadian law that would have necessitated this case being heard on the national importance question. Unfortunately, it's going to take another case where somebody tries to argue a novel duty of care between a regulatory body and the person or company being regulated until the Supreme Court of Canada has another opportunity to hear this. And with the precedent being what it is, that's not likely to happen for very long. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, share with your friends, and tune in next week.